Hello, welcome back. GovDoc Breakdown, no opinions, just facts and summaries of government documents. And today we're back, June 18th, Supreme Court opinion, Oklahoma v. the EPA, Environmental Protection Agency. And this is a sausage alert, ladies and gentlemen. Sausage is being made, baby. This case addresses where legal challenges to certain Environmental Protection Agency actions should be heard under the Clean Air Act. Specifically, it deals with whether challenges to the EPA's disapproval of state plans, called State Implementation Plans or SIPs, for controlling air pollution should be reviewed in a regional court or the D.C. Circuit Court. Remember, cases involving federal agencies go straight to the Circuit Court, no district, right? So we got EPA, they're making a rule or a notice or a ruling, so challenges to that, straight to the district court. Or no, straight to the circuit court, no district court. District court, circuit court, Supreme Court, as we know. All right, background of the case here. In 2015, the EPA made the ozone standard stricter, which required states to submit new SIPs, state implementation plans, to comply. The EPA reviewed these plans and disapproved of 21 because they did not adequately address the good neighbor rule, which basically says you should be a good neighbor and not let your air pollution affect other states. So the EPA combined these 21 denials into one single national action and told states that any challenges to the decision would have to be heard in the D.C. Circuit Court because that is who takes care of cases with nationwide impact. Several states and industries challenged the EPA's disapprovals in regional courts, however, arguing that each state's SIP, State Implementation Plan, disapproval was a separate local issue. Regional courts around the country disagreed, which led to the Supreme Court case we discussed today, Oklahoma v. EPA. So one thing we need to know before we look at the decision, the Clean Air Act classifies actions as nationally applicable or locally/regionally applicable. So the Supreme Court here had to decide, are the EPA's disapprovals of Oklahoma's and Utah's SIPs nationally or locally regionally applicable? And two, if they are locally/regionally applicable, does the nationwide scope or effect exception apply, requiring challenges to go to the D.C. Circuit? So there's an exception to that rule saying if it's nationally applicable and affects the entire nation, then you have to go to the D.C. Circuit. So the Supreme Court ruled that the EPA's non-approvals of the SIPs were locally or regionally applicable. The court determined that the EPA's action is not a single combined rule in the Federal Register, but rather the individual disapproval of each state's SIP that they submitted. The Clean Air Act treats each SIP approval or disapproval as a separate action that only applies to a specific state. Secondly, the EPA ruled that the nationwide scope or effect exception does not apply because the disapprovals were based primarily on state-specific, fact-intensive analysis and not nationwide factors. So, this clarifies that local courts get to handle disputes about state-specific plans related to the air pollution rule implemented by the EPA, unless the EPA's decision clearly affects the whole country. All right, Kaimo, keep your mind open. Do your own research, form your own opinion. See you in a little while.